Good evening and welcome to Face to Face. For the Newsfirst team, I'm Niresh Eliathambi. My guest tonight is Mr. Akshay Jaitly, who is a lawyer from India, and he is one of the founding partners of the Indian law firm Tri-Legal. Good evening and welcome to the show, Akshay.
Thanks, Nilesh. Thanks for inviting me.
Right. Akshay, tell us about your firm, and it is quite an interesting one, and you've written a book about it, Tri-Legal, and you have now celebrated, I think, 26 years in existence. Tell us about the distinctiveness of your law firm, as opposed to the traditional law firms which we find in our part of the world.
Well, you and I are roughly the same age, so you'll appreciate me perhaps placing this in historical context. I think law firms have existed in India at least since the 1830s. But what they looked like and what they felt like was quite different until 1991, when we had our liberalization and our economic reforms. What those reforms did was open up the economy both to foreign capital and, as a consequence, to new forms of doing business, to new transactions, new sectors, etc. And the existing law firms, the traditional law firms, which tended to be family owned or dominated by single individuals, with a few exceptions, they needed to sort of up their game in order to meet with the challenges that a reforming economy presented itself. And 1991 is when that started. And 1994-95 is when the founders became lawyers, when we qualified out of law school. So we entered the job market or the law firm world in the early days of a liberalizing Indian economy, which gave itself a whole lot of opportunities for legal practice in new ways and new means than had been done before. And whilst the traditional law firms had more years of legal experience, they didn't necessarily have it in the new sectors and with these new business models. So we had this opportunity potentially of getting into the market and being able to, with a few years of experience, because if we qualified roughly in 1995, we set up the firm in the year 2000 with just 5 years of experience. But it was sort of a bit like the Wild West in terms of what the opportunity landscape was. And we felt at that time that the structures of some of the traditional firms, or most of the traditional firms, were not best suited to the reforming economy that India now saw itself having. Or at least, at the very least, those were not structures that were attractive to us as the founders. And by that, family firms tend to be closely held. They tend to be the pathways to advancement tend to be somewhat limited. There are opportunities for good lawyers, but not necessarily opportunities to become leaders of the firm and, people who can shape the future of the organization itself. And one thing that lawyers around the world share is that they tend to be pretty individualistic. Law, after all, is a profession. It is, while we may be grouped together in firms, there's a sort of independence-mindedness that you retain as a lawyer and a pride in being a professional who could set up their own practice by themselves and who don't really need to be part of an organizational structure if they didn't want to. So we felt, however, at the same time, law firms need to be more than the sum of just agglomerations of lawyers and more than the sum of their parts. So being under the same roof should bring benefits which are over and above those that just a group of lawyers working together could have, which is the model of barristers' chambers in the UK, for example, where you share costs, you're under the same roof. There are a few things that you share in common, but otherwise your individual practice is under the same roof. So we wanted to maximize the benefit of being together and being able to work collaboratively, while retaining that independence-minded entrepreneurial spirit that lawyers and we had at the time. And what that meant was to set up with a set of values and principles that were different from, we think, what came before. So we emphasized things like meritocracy, equality, one partner, one vote from day one. We were very ambitious. Even in the early days, we thought of our competition as the biggest firms in the country, which was perhaps a bit cheeky of us to have done that in those days, but we were cheeky. And also to have this sense of putting the institution at a higher pedestal than yourself. So you could call it collegiality, you could call it collaboration. We called it firm before self, which is a slightly more grandiose way of saying that, but it's still, these principles still remain principles of the firm today.
Now, another interesting aspect is that you and your partners launched in several cities at the same time. What was the thinking behind that?
It was more a function of circumstance than of any grand plan. It turned out that it made most sense because the three cities in which we launched, Delhi, Bombay and Bangalore, for different reasons are the three most important economic centers in India. Chennai is also very important, but these are definitely the first three that come to mind in different sectors. But the reason it happened was because there were two of us who were from Bangalore, there were two of us who were from Bombay and two of us who were from Delhi. And none of us wanted to move to any of the other cities. We tend to be reasonably parochial in those terms. But also because if you grow up and if you have your initial practice in a certain city, you develop a network and a cachet, which is your own context, in which you're more effective. I wouldn't have been as effective in Bangalore. At least it would have taken me some years to come up to speed. Whereas in Delhi, I knew the rules of the game a little better.
And you've now opened in Chennai as well.
We opened in Chennai late last year.
Right. So it's interesting that the launch of your firm sort of mirrored the opening up of the economy of India, which offered so many opportunities.
Yes, absolutely. I think when people ask me about the reasons for the success of the firm, my number one reason is chance. We were at the right place at the right time, and there were 6 of us who got along with each other. We shared similar values, and we didn't hate each other at any point in time. So, these things there's a bit of an alchemy, and I use that word in the book, to a successful business. And we were just lucky in that sense.
Now, your firm has grown from that initial 6 lawyers to what at the moment?
We have 1,200 lawyers approximately, amongst which there are 160 partners.
160 partners. So even your profit sharing and the mechanisms of operating within your firm must be quite different from the traditional.
Yeah, I can't really speak in much detail as to how the other firms are structured. I do know that we are different. I just don't know the extent to which we are different. We are different in some key respects. One is the one partner, one vote, which we've had from day one, as I mentioned. The other is that we are an all equity partnership. Many law firms, not just in India, but around the world, tend to have salaried partners, people who are called partners but are paid salaries, and then they get a bonus based on their performance. For us, for all practical purposes, everything that any partner builds or generates, any revenue, all goes into the same pot. And then it is shared out according to the amount of equity that a different partner has. That's one important element of it. The second part of it is that our equity is divided into a number of points or units. And the ladder of equity goes from 5 points to 40 points. So in the beginning, us as founders, we were at 40 points from the beginning. And the partners entering the equity entered at 5 points. And based on certain performance criteria, partners get more equity points each year. So if performance was good every year and a partner went through the system very smoothly, in 13 years, they would reach the top of the equity. So, and they would be at the same level as the founders.
That's quite rapid.
That's quite rapid. So if you become a partner after 10 years of practice or 10 years of experience in the firm, and then another 13 years of being a partner, in 23 to 25 years, all going smoothly, you're going to be at the same level as the founders. So that is quite radical. And in fact, so radical that for several years, we couldn't convince people that this was our system. It took some laterals joining us from other firms and experiencing the system for themselves, going out and telling the world, no, actually what these guys are saying is what they actually have, because it was so different. And even now, you'll struggle to find a firm in India which has all these elements under one roof.
Right. Very, very interesting indeed. And do you feel that this type of model could be implemented in other parts of South Asia as well?
I don't see why not. And I'll give you a couple of reasons why I believe that. One is external. I think the way the world is changing and the way that people's attitudes in the workplace are changing, young professionals, and as I mentioned earlier, especially in the legal profession, are not content with just being glorified employees. They want to feel like they have a stake in the business of law, in the structure of the firm itself and its future. So that requires not just the freedom to run your own transactions, but the ability to feel like you own what you're doing and to be a co-creator of the business as you go along. So that's one important reason. And I think as our economies become more complex, the kinds of services that clients look for are varied, and no one or two or even five lawyers can deliver that. So you can't be in a complex system, you can't be a derivatives lawyer and a capital markets lawyer and do an infrastructure project and provide advice on data privacy as one lawyer. You need different people to do this. And if you want people who are considered experts and who are motivated as strong independent professionals in their own right, you again have to give them some stake so that they both have that credibility in front of clients as well as the motivation and incentive to deliver the best advice. So I think that it's entirely possible, and I'm hoping that the world will move towards that. The other set of reasons is, I think, rooted in what I think is a bit of a mistake that people make when looking at a capitalist economy. Although people in a capitalist economy or in a microcosm of that, which is a profit-making law firm, are motivated by profit and by making money, I haven't met anyone who's only motivated by money. And I, for instance, am certainly motivated by a bunch of other things. And I have no reason to believe why other people are not as well. And amongst those, and what's important in the context of a law firm of the type that we are discussing, is the idea of collaboration, teamwork, and trust. People like to feel trusted. They like to be able to trust other people. People enjoy the feeling of working in a collaborative environment. Anyone who's played a sport has felt that benefit of teamwork. It's much more exciting when you win with others. It's easier to take a loss when you lose with others. So that sharing of a journey and the sharing of work, it sounds like a woolly concept, but I have experienced through my professional career and the structure of our law firm that people, even if they don't want to admit it because it's considered to be slightly weak and slightly nice, quote unquote, I think people are motivated by these things. So a firm that can capture both the profit-making objective as well as this desire of people to work as teams and collaborate and in collaboration towards a common objective, I think there's a recipe for success there. And if you're providing for these elements, then the exact structure or the formula that you use doesn't matter so much. It just has to represent these principles.
Now, you spoke of the younger generation. And would you consider that your model of a law firm would be better suited to cater to the aspirations of the younger generation?
I think it is. However, I think it's not fair to expect a 22 or 23-year-old coming out of law school to be motivated by slightly grandiose ideas of this kind. I think there will be some who are, the ones who are more reflective and a little more mature. But a young person at that age is interested in doing quality work. They're interested in working for a good brand, and they're interested in being paid well. I think once that's out of the gate, out of law school. But over a period of time, I think these principles that we've been talking about, they are reflected in practices, day-to-day practices in the workplace. How does your boss speak to you? Is your work valued? You get a pat on the back if you do well. If you're asked to work over a weekend because a client demands it, is there something nice that is said to you at the end of it? Those sorts of, if the structure of a firm lends itself to that kind of workplace environment, then young people over time will gravitate towards it. And I think we've been reasonably successful. Certainly not perfect, but reasonably successful in creating an environment that hardworking, young, motivated people gravitate towards to a certain extent.
But how do you make legal work more interesting? Because, as you said, the younger generation aspires to do more, to work on interesting projects. How do you make legal work interesting?
Well, I think it depends. There's some legal work that is interesting, from the beginning. If there's a new legislation that comes out and you're asked to analyze certain features of it and see how it's different from the previous legislation, and based on certain criteria, how would that affect a client's business or their actions going forward, that's pretty interesting intellectual work to be doing. Not everybody gets that work. To paint a completely different picture, you could find yourself on a weekend late at night in the office going through a stack of board minutes from a company which you're doing as part of a due diligence pursuant to an acquisition. That isn't glamorous. That does not fit with any image that you've seen in the media of life in a law firm, which is always glamorous, exciting, fast, and many other things. So what I find useful in that situation, and what I say to some of my younger colleagues, is contextualize what you're doing. Look at that piece of work as part of a larger transaction. That larger transaction, there are reasons why it's happening. There are reasons why the two entities who are engaging in that transaction are doing it. There are reasons why they're doing it with each other. It could be that transaction has come into existence or become more viable because of a policy change. Say in renewable energy, there's a subsidy that's been given that has made it more attractive to do a certain kind of project. It could be that companies relocating a business out of one country to India because of tariffs that a third country has imposed. So they are both deal-related, sector-related, national and international contexts to the work, or could be to the work that you're doing. And the more you engage with those contexts, which requires curiosity, the more interesting even a mundane piece of work could be. Now, this is not, there are days when I have felt bored with the work that I'm doing, and that's normal. I would just encourage a bit of patience and in waiting for the interesting work to come, contextualize the work that you're doing and see the larger relevance of it. It'll make you feel a little more important, even if you're not the most important person on that deal.
Right. Now, in today's world, deals can be in billions of dollars. And of course, it can be, shipping or petroleum or more and more tech, especially with the tech firms of the West and also India. Are Indian firms, law firms, well positioned to take on such work? Do they have the expertise?
Yes, they do now. I think, and I mentioned this in the book quite specifically, I think that at the top end, the Indian lawyers are as good as the best lawyers anywhere in the world today. On the transactional side and for litigation, that has been the case for a while. The top Indian litigators have been exceptional and outstanding. I think, we have now been doing international standard deals for 30 years since liberalization happened, and since, 25 years within the firm. And I think, you develop ways of doing business or not just on the business side, but ways of doing transactions, and you see how transactions are done over years. If I can just paint a little picture going back, in the early days when I first started practicing, I worked in an English firm in London. And if there was a deal happening in India, the English firm would do 80-90% of the work. And the Indian firm would do 10 to 20%, ensuring that the deal effectively was, in compliance with Indian law and that sort of thing. Today, the standard model for an international firm passing work to an Indian firm is, here's my client, here's a deal, look after my client, please, thank you, and let me know when the deal is done. So that's a long journey that we've traveled. For some of the biggest international deals, if there's a multi-jurisdictional acquisition taking place, then it's likely that an international deal will keep tabs of what's going on in all the jurisdictions where that deal is happening. But the default now is that for the largest deals that are happening just in India, it is just Indian law firms involved. There are a small percentage where international firms do get involved, largely when it's an English law financing or similar kinds of issues. Significant legal component that requires foreign legal expertise as opposed to just transactional skills. So that's a very, very big change. Another example of that, Nilesh, is that Trilegal, we are doing, and I'm sure there are other firms that are doing this as well. We have done a large number of transactions now, probably around at least about 50, which have been outside of India for non-Indian clients with no Indian involvement other than us as a law firm. So we have become the international law firm, so to speak, on that deal, and we engage local counsel in Egypt or Vietnam or Papua New Guinea or Fiji or Kenya to do the local law advice, the sort of stuff that we were doing 25 years ago on deals coming into India. So I think that's another example where international clients have got comfortable with us, working with us in India, and say, look, why don't you do this work for me overseas, rather than a firm out of London or New York, which is twice or three times or four times our cost.
India's economy is growing. It's one of the fastest growing economies in the world, and its projections for the long term are excellent. Is the Indian legal situation well positioned in terms of law firms to take on this kind of work?
Yes, I think I'm a great believer in the market and in supply and demand. I think that the faster the economy grows, the faster law firms will grow. We still sometimes struggle to hire, although there are lots of lawyers that are produced in India every year. We still struggle to hire because the top end of that market is still quite thin. But I think it'll lag of a year or two, and the growth will be catered to largely by Indian law firms.
Interesting indeed. And where do you see the Indian legal fraternity position with regard to the rest of South Asia?
I think that larger and more complex economies will tend to produce professionals who are perhaps have more experience of doing those complex transactions. I have to confess, I'm not an expert on what's going on in Sri Lanka or Pakistan or Bangladesh, but I suspect that because of the sheer size of the Indian economy and therefore the consequent interest of a larger number of international companies doing business in India, that just provide opportunities to Indian lawyers to do some of these more complex deals. So I think that I actually wish that we had more openness within South Asia to do deals in each other's countries. But both India and Sri Lanka are pretty closed legal markets for foreign law firms. Otherwise, I think there may be some interesting opportunities to explore and know-how and ways of doing business that we could share with each other on a practical basis.
Now, when you were setting up your law firm, what were the major challenges that you faced at the time and also throughout the last 26 years?
I think when we were setting up, the major challenge was being known at all. Why would a client trust you with some work? Now, we'd had, as I mentioned earlier, we had 5 years of experience, so we'd worked with some clients, and some of them were happy or foolish enough to trust us and say, I'll give you some work. And perhaps it wasn't all their work, perhaps it wasn't their most important work, but even if they stayed with the law firm that they were with, they gave us a little bit of their work. And then, and again, as I mentioned earlier, because some of these sectors were opening up, if you could do your background work and research on a transaction that was novel or in a sector that was new, and if you could demonstrate to a client that you knew enough to do their work, then there was a chance for you to get that deal. Today, that will be a lot harder because Indian law firms are much bigger. They have all kinds of expertise, and no one can say, oh, nobody else has this expertise, because most sectors of the economy are now open. So that was a big thing. I remember one example where we were pitching to the IFC, to the International Finance Corporation, on a project where they were advising the government of the state of Punjab to set up agricultural silos on a public-private partnership basis. And part of the pitch that we had to make to them was to evaluate the legal and regulatory framework and give them our sense of how suitable was it for this project to take place, and if there were any changes that needed to happen, and what kinds of transaction structures would be needed for this or could be derived from this legal and regulatory framework. We effectively did half the work that would be required on the project for the pitch in order to be able to show the IFC that we could do the work. We showed our hunger by having done their work. We also showed our ability to understand, digest, and also then provide some tentative solutions, or at least early stage solutions about which direction the project could go in. We got that mandate, and that led to what has now been a over 20-year relationship with the IFC, and we've done projects for them not just in India, but as I was mentioning earlier, in other countries as well. So I think that's what you need to do in the early days to get known. Over the course of the last 26 years, I think the biggest challenge that a law firm of our kind faces perhaps is a balance that you need to build between meritocracy and collegiality. Meritocracy and this spirit of firm before self, or sharing. I mean, it's on the one hand, if you have an exceptional performer, somebody who's very, very good at what they do and can bring in huge amounts of work, one form of meritocracy would be to say, please compensate them disproportionately because they are bringing in disproportionate amounts of work. That sounds fair. At the same time, our system, everything goes into a pot and is shared out, and that creates a system of collaboration. It actually lends people to work together, to pass on work, and to grow together. That's also a good thing. How do you balance these two good things, which are sort of in opposition to each other to some extent, over a period of time, is something that we've grappled with throughout, and it's been reflected by small changes we've made to our compensation structure over the years. So for instance, we didn't have this originally, but we have a small bonus that partners get. It's a very small amount. It's for all the partners getting a bonus in 1 year, it's limited at 5% of the revenue. And so if the criteria for eligibility, if there are 4 partners who are eligible, or if there are 10 partners who are eligible, the amount doesn't change. So you get a smaller piece if there are more partners. But it's really like saying, thank you for a great job done, as opposed to here's compensation for a good last year. It's more of a thank you. But as I mentioned earlier, our system, if you perform well, you get more points every year. And that's the real reward. The real reward is that you keep going up the ladder and you are on a higher base of compensation altogether rather than just being paid for 1 year. So this balance between individual performance and collective benefit it's an ongoing challenge.
Now, Akshay, your book, Trilegal, is the name of the book as well, the name of your firm. It's received a lot of good reviews, and I did read through it, and it's very well written in excellent, easy to read English. What was the thinking behind writing this book, and how long did it take you to write this?
It took about 18 months, of which the first 12 were slow and painful. Because, as I always say, lawyers are boring writers typically, because our writing has to be unambiguous and clear and not capable of multiple interpretations. You tend to write in a dry fashion in your day job. But so for that reason, about 3 or 4 years ago, I decided that I would give myself an exercise of writing a 300-word blog every day for a month, on various topics to loosen up my writing style. So I did that, and 2 or 3 of the topics that I chose to write on were the early days of the firm. And because they were work related, I put them on LinkedIn, and I got a great response, and people said, we want more of this. And other people said, no, you should just write a book, and don't make it just anecdotal. These were sort of funny stories about our early days. Don't make it anecdotal. Write a story about institution building, because you've actually built an institution. So then I tend not to take that side of things too seriously. There are other areas in which I take myself seriously, but not necessarily. I didn't think of myself as we didn't think of ourselves as institution builders. But it turned out that we were a little bit of that, and that there was a positive story to tell. And I think it's good to share positive business stories. There isn't enough of that. And certainly in India, this is the first book on professional services firms that explore how they function. There have been books that have talked about 100 years of this firm and, talk about the history of the firm and the achievements and all of that. But this is a book really on how to run a business, how to incentivize people. And you could take this and apply the lessons of it to a startup in any sector. It's effectively the story of a startup that's done well. So it was a positive story to tell in an area in which there hadn't been much writing at all. And it also coincided with our 25th anniversary. So for all of those reasons, and also my partner said, yeah, go ahead and do it. And of course, I needed my first constituency for the book were my co-founders. So every word in this book, they at least have no objection to. Even if they don't agree with it, they don't object to it. And then for me, the most gratifying thing was how much our own partners have responded and identified with the book. And then beyond that, and that's one of the reasons I'm in Sri Lanka, even beyond India, people have sort of liked the story because I think there is something positive to it. So it's nice for that to happen.
Excellent. So we need to take a short break now. I am with Mr. Akshay Jaitly, who is a lawyer from India, and we're talking about his book, Trilegal, and also about the legal systems in South Asia. Don't go away, we'll be right back.
මේකේ තේරුම එක්ක අපි හිතපු විදිය වැරදි. එහෙම නැත්නම් මේකෙල්ල අපට වඩා කපටි. ඇහුණද යාට?
ඇහෙන්න ඇති. අනිවාර්යෙන් ඇහුණා.
Learned from that the national interest, why we haven't achieved them. Obviously, we have not achieved all our national potential.
The two essential principles to this scheme are something called most favored nation. That is, if one country gives, one member of the WTO gives a particular tariff to one country, it automatically applies to all the other members.
ෆෝන් එක අරන් විතර a reverse osmosis water purification system for Digamandala Primary School, Ampara. A promise of a healthier tomorrow. Gammatha, for the people, by the people.
Welcome back to Face to Face. I am with Mr. Akshay Jaitly, who is a lawyer from India and the author of the book Trilegal. To give our viewers a little bit of background on Akshay, he is of course one of the founding partners of Trilegal, the law firm, and a member of the firm's governing board. The firm is of course it has offices in Delhi, Bombay, Bangalore and Chennai. Akshay has over about 30 years, he's advised on projects in a variety of sectors, including power, oil, gas, transport, water and waste. He also provides clients with strategic advice on their investments in these sectors. He's actively engaged in advising on policy issues, particularly in infrastructure and energy, and he writes regularly on India's energy transition. His education, he has a Bachelor of Arts in Jurisprudence from the University of Oxford, and a Bachelor of Arts with honours in history from St. Stephen's College of Delhi University. He also holds a Master's in International Affairs and Law from Columbia University. Right, so Akshay, let's talk about one of the new aspects which affect law, and that is AI. And this has caused some disruption to jurisprudence, but it is also very helpful. So what's your view on AI and the law?
Well, I think anyone predicting the effect of AI on anything is taking a big punt and a risk, and probably doing it to attract attention to themselves more than anything else. So I'll hesitate. And also I'm not a tech specialist, so I don't even have a specialist's take on how this is going to go forward. But as a lawyer in a law firm, and as someone who is familiar with and uses AI myself, I think that there's one particular area that will require attention. Firstly, I think it's important to say that I don't think lawyers are going to be replaced by AI in a hurry. It may happen in some future world, but not in a hurry. Lawyers will be replaced by lawyers who use AI. So you need to be a lawyer who uses AI to be relevant in the future workplace. It's not just that AI is going to replace a lawyer. What's happening, and this is an interesting phenomenon, is that clients actually ask you today, what is your AI use policy? They ask you that from a security perspective, but they also ask you that from an efficiency perspective. They will expect you to use AI for certain types of work. They will actually list the types of work, sometimes the more sophisticated ones, where you are permitted to use it and where you're not, and where you are expected to use it. So the area in which I think there's going to be discussion and exchange, and I think even negotiation between clients and law firms, is going to be on the value of a junior lawyer's work. Clients will legitimately say, why should I pay X amount an hour, effective rate, for a lawyer with 2, 3, 4 years of qualification when 90% of what they do could be done by AI? That 90 could be 70, 80, doesn't matter, but when a large chunk of their work can be done by AI. That's a fair point. My response to that would be fine, but if you want a lawyer to be a good senior associate and a good partner in the future, they need to learn. And historically in our sector, people have learned by doing. In most sectors, people learn by doing. So if you're going to take away that opportunity to learn by doing, by the use of AI, then we have to make sure that they learn through other means, which can only be training and training using AI. Now, training using AI and paying people while they're getting trained costs money. Somebody will have to pay for that. And if earlier you were paying for that person's time in the form of the hours that they were working for you in billing, then you should be at least prepared to pay a certain amount of that, if not all, when they're being trained, so that they're available for your work in the future. Otherwise, you're going to have people who are going to have a large amount of experience. So this is a conversation that is going to have to happen between providers and users of legal services, so that we come to a point where there's a reasonable understanding of course, how we use AI, but at the same time, how do you make sure that the humans that are being, not replaced, but temporarily being replaced by AI, how do they learn? So I think and it's not just in the legal profession, but any knowledge-based sector. I think this is going to be something that will have to be grappled with.
Now, speaking of clients, what does the modern business client really want? What sort of distinguishes modern clients from those perhaps 30 or 40 years ago?
I'll tell you what they don't want. They don't want a 25-page memo which is annotated with case law and lots of footnotes about, in answer to a question of how do I do these 3 or 4 things. A client today is going to presume that you know the law and doesn't need evidence of the fact that you know the law. They're going to presume that. It's certainly at the top level of end of the practice. Clients want answers to their commercial questions. Now, I think commercial lawyers who advise companies, need to think of themselves as enablers of business. We exist because our clients exist. Our clients want to achieve a certain commercial objective, and we are helping them do that. We are using the pretty sophisticated and intellectual tool, which is the law, in order to do that. But that's what we are doing ultimately. We are high-level service providers. At the same time, of course, there is the side where there's delivery of justice. All of that hasn't changed. But on top of that, we are also high-level service providers. Now, what I would encourage lawyers who are, starting out, is to put themselves in the shoes of the client. Why is the client asking me these 4 questions? Are they the right questions for them to be asking me? In order to be able to answer that, you have to ask them, why are you asking me these questions? Are you trying to achieve X? If you were trying to achieve X, maybe you need to ask me these 3 other questions itself, and maybe these 2 are not relevant. So I think it's really that business enabler, even more so now. And you were talking about tech earlier. For the development of certain tech products, our lawyers now get involved in the design stage of the product itself. Because tech being a digital product, the regulation of that technological product has to be designed into the product itself. Fintech is one of those areas. When you're providing, what you're allowed to offer in an app which is providing some financial services is dictated by financial regulation. And that financial regulation has to be built into that app from a technological perspective. So somebody can't build an app and then come to you and say, is this compatible with the law? The best clients will engage the best lawyers to bring them in at the product design stage saying, I'm planning to design like this product like this. Is it in accordance with the law? Because otherwise you lose time and money if you come to the lawyer later. So that's the extent to which we are sort of business partners of our clients today. And you need to know the sector and the industry of your client really, really well to give good advice. Because it's not just a question of using the legal environment and the regulation to provide the advice, but also to understand what are competitors doing, what is market practice, if there's an ambiguous area of regulation, which direction is this likely to go in given the past behavior of the regulator. So it's really a lot of different things in one. And that's what makes it such a fascinating and exciting profession, I think.
Interesting indeed. Now, let me ask you about the judicial systems, the legal systems in South Asia. When you compare them with developed nations, let's take Singapore or the European Union, one of the key differences is that justice is dispensed with much faster in those developed nations, and that's one of the pillars of their economies, that they are able to say, well, if you need to go to court, the case will be dispensed with very quickly, whereas in South Asia and in many other parts of the world, it takes literally years or even decades. Of course, there are perhaps in Sri Lanka we have the commercial high courts which work faster and so on. But how does the legal fraternity get involved in streamlining this? Because it is in fact a huge issue when it comes to attracting foreign direct investment.
No, you're absolutely right. I think that the structure of the legal system, to the extent that it faces economic activity, should be thought of not as a separate part of a country's life, but very much as part of the country's economic system. Because it is the scaffolding on which the economy runs is the operation of law. And you can have great law. In many areas, laws in India, laws in other parts of South Asia are not very far behind, if not as good as, in some cases maybe even better than laws in the European Union or the UK or the US. But it's a question not of the quality of the law itself, but how quickly, effectively, consistently, and non-arbitrarily is it actually applied. And those things taken together is what actually constitute the rule of law. So, the old adage that justice delayed is justice denied exists even in the context of contracts. I might have a great contract. The contract law in my country might be perfect, might be fine. But if the court is only going to rule on my contract in 5 years' time, that's too long in terms of the ways that business cycle works, which is in months and year and quarters rather than in years and decades, as you were saying. So I think that we do ourselves a bit of a disservice if we don't pay attention to the administration of justice, because all the other great things that we are achieving in our economy, certainly in India, what we've done on the digital side with digital payments and that sort of thing, we are not maximizing the benefit of those advancements because we don't think of the dispensation of justice or the administration of contracts as part of the economy as closely as we should. So the way that lawyers get involved, that we get involved sometimes, is by making representations to government as part of industry bodies on behalf of clients. And in our case, me and one of the other trilegal founders, Karan Singh, we've set up a not-for-profit called TrustBridge, which does exactly this sort of work, which is looking at how effectively do regulators function. What is the quality of regulatory orders? Because the quality of an order lends itself to more faith and belief in that dispenser of justice. So I think I think many lawyers in India, and I'm sure that's the case in Sri Lanka as well and elsewhere in South Asia, once you develop a body of work, you tend to get you pattern recognition on where the big problems lie, and then you start moving towards some degree of policy work if you care about the larger environment within which you're engaging in your profession. So those are some of the ways that we do this, and it's it's a uphill battle and a long road, but it's something that I think that many of us are drawn towards, because ultimately it's a question of what's fair. And what's fair is a it's one of those reasons that most of us who get into the law, we start off by, I want more fairness in the world. And more fairness in the business world is what we've been talking about in the last few minutes.
What about alternative dispute resolution mechanisms such as arbitration? What role should those be playing?
I think arbitration in India certainly has become much, much more important. It's the default for most commercial disputes in many, many cases. I think ultimately, while it does speed things up, I think arbitration, or the effectiveness of arbitration, ultimately relies on how well the courts are functioning, because potential appeals from arbitration lie to the courts. And while the grounds for appeal in arbitration are much smaller, they're usually on procedural basis, we find that even arbitral awards, when they are appealed in court, those appeals take far longer than they should, and there are far more stages to that appeal than there should be. So I think the courts are seized of this and they're trying to reform, but it's something that is not ideal. So I think, if you say what is arbitration, the existence of arbitration, what does it point to? It points to the fact that the court system isn't working as well as it should. So should the option be to opt out of the court system partly by going towards arbitration, or should it be to focus on improving the court system? And as you mentioned, you've got the commercial high courts. We also have commercial benches within our high courts in Delhi and Bombay, and they do function a little more effectively. So I think progress is being made, but I think we could justifiably be slightly dissatisfied with the pace of progress.
Right, some important points there indeed, and I'm afraid we are out of time. Thank you very much to my guest this evening, Akshay Jaitly, who is the author of the book Trilegal. Thank you for joining me. And thank you to you at home for watching. Don't go away because the news is coming up next. Have a great evening.